Okay. All right. Good afternoon. I'm Samantha from the law offices of Samantha Wolfe, and I appreciate everybody being on this afternoon. I really do appreciate it. Again, I'm going to ask everybody to be on mute. We do have a chat box though, so as I'm going through the session, if anybody has any questions, you're welcome to enter them into the chat box, and I'd be happy to answer them as we go along. I'm going to give the presentation, and then you can ask questions as we go along. You're also welcome to ask them at the end too. I'll leave some time then. Okay. So with that being said, let's go ahead and get started. I'm going to share my screen. So let me do that.
Denise.
Okay. Okay. So hang on just a second. I think my mom just got on and she may not be on mute. Okay. I always appreciate when my parents are supportive. Let's see if I can get her on mute. Okay, there we go. All right, thanks, Mom. I love you. Okay, so today's presentation is called What's in Your Closet? It's actually the first part of a two-part series. So the second part we're going to go over in October. And in October, I'm going to go over some tax concerns and some tax issues that we have with trusts. But what I wanted to do today is I wanted to talk about creating an asset protection plan, why you need them, how you can do it, talk about some of the legal ways, and then go through how at our office we would do it. So I do have our contact information on the bottom of the screen. We're located at 20 East 6th Street in Suite 206 in Waynesboro, and our number is 717-655-2676. Okay, so today's topic, I'm really excited about this one. Not that I haven't been excited about the other topics, but I think this one is one that I'm not sure a lot of people have a lot of background information about. And so it makes me excited to be able to talk about these topics. So as we go along, like I said, use the chat feature if anybody has any questions, and I'll try to answer them as we go along. And I know that Amy and Tammy from my office are also on here. They're going to be watching the chat box as well. So who needs asset protection? So, physicians, we think of doctors, physicians, attorneys, CPAs, professionals, financial planners, insurance agents, business owners, property owners. So a lot of times when I'm meeting with clients, they come in with the perception that they don't need any type of asset protection because they don't fall into any of these categories that I have listed. But what I'm going to talk about today is that anybody who is on this call and has assets that they would like to either protect for their spouse, or they would like certain assets to make sure that it's going to the next generation, then asset protection is something that you do want to talk about, or at least explore to make sure that there's not something more that you should be doing. And when we think of asset protection, it's taking the basic estate planning documents. So for anybody who I have met with on the call or any potential clients that I have, we always start with those basic estate planning documents: the financial power of attorney, the healthcare power of attorney, the living will, the mental health power of attorney, and the last will and testament. Those 5 documents, the last 2 virtual seminars, July and August, we have really focused on those basic estate planning documents, and everybody should have those basic estate planning documents. What asset protection does, an asset protection plan just kind of takes it a little bit farther, and it says, okay, you have the basic estate plan down, but now you want to be doing something more. There's another goal you have, whether it be protecting your spouse or, like I said, protecting the next generation. That's where asset protection comes in. So what are you looking to get protected from, or what's the protection from? So it could be from divorce, could be death, could be debt, or it could be disability. And when I think of anybody planning for the second half of life, what I'm thinking of is a nursing home. That's always the biggest creditor that we think of as we age, is a nursing home. And so it could be that you're protecting you, it could be protecting you and your spouse, and then it could continue protecting your future generations. So that's why when we talk about it, it's you, the beneficiary, or both people can be protected using an asset protection plan. So how do you protect assets? So there are 2 main ways you're going to do it. The first way is irrevocable trust. That's the legal method that we're able to use to protect assets. against any type of creditor, the biggest being a nursing home, is that legally we're able to use irrevocable trust. And I'm going to get into that a little bit in detail as we go through the presentation. I'm going to give you an example of how we use these irrevocable trusts. But the other way that we can do it is that it's some sort of investment product. So it could be you have a traditional long-term care insurance policy. It could be that you have a life insurance policy with a long-term care rider. It could be that you've met with your financial advisor and you've leveraged buying some product that's going to cover you through long-term care. Even if you have a product like this, I always advise people to have your legal professional look over that contract because, for example, earlier this week, I met with a couple and they have traditional long-term care insurance. And so they have, both of them have a policy, an individual policy. And so things like, when does the coverage start? How many days of care does it kick in? What is the daily limit? And then what is the overall limit for the policy? So oftentimes I see that you'll get a minimal amount of coverage, like they'll cover $250 a day, but anything more than that, the insurance doesn't cover, and you are going to have to pay that. So it's figuring out where's the shortfall. And then the shortfall is that you're either going to privately pay or you're going to qualify for Medicaid if you don't have enough assets. The irrevocable trusts come into play because if it's in a trust and it's been owned by that trust for 5 years, then a nursing home cannot look at that asset as an available resource when they're looking to see what you can privately pay. Now, that's not to say you cannot use those assets in the trust. It's just saying that there's no legally enforceable obligation to do so if you've made it past the look back period. And in Pennsylvania, that look back period is 5 years. So if somebody sets up an irrevocable trust and transfers assets into that trust, those assets are not fully protected until they've been owned in that trust for 5 years. And unfortunately, in Pennsylvania, there's not a pro rata, or they don't say, you've made it through 3 years, or it's all or nothing. So it's beneficial for couples, especially, to do planning sooner rather than later. And again, I'll talk a little bit about the mechanics here, but really what this slide is really designed to do is to remind you that we can do it with irrevocable trust. We can also use investment products or insurance products, and sometimes we can use them together. So for example, we have a lot of clients who do have a policy, but their premiums have continued to increase year to year. I had somebody who their premium increased 17% from 1 year to the next. And so what I was able to do is meet with them, talk about irrevocable trust, position assets certain places. They paid through the policy until their 5-year look back period. They got through that. And then the trust kind of took over, and then they could stop paying the premium and let their long-term care insurance policy lapse. The other thing you can do is you can still use them in conjunction with each other, because even if you continue to pay it, like I said, there's oftentimes a shortfall or a limit. The maximum will be $200,000 that policy will pay out. So this irrevocable trusts are helpful after the long-term care or life insurance product, whatever it is. Once that coverage runs out, then the trusts kind of come in and protect. So what is an asset protection plan? So here in our office, we actually like to do a written plan and a visual, and I'm going to show you an example of that later on. But it's designed to help clients protect wealth and assets from creditors related to actions of others. So the best example would be car accident, somebody sues you, can protect assets from that, can protect against divorce as well. An asset protection plan, though, is also positioning clients in the best tax structure to minimize their overall taxes. So these trusts that we talk about, that I'm talking about in this session, that's what part 2 is about. We're going to talk all about how they work tax-wise, and I'm going to go over all the different types of taxes that are going to apply when you pass away and how these trusts work with that. Okay, so you want to make sure that your asset protection plan puts you in the position to be able to be in the best structure. An asset protection plan is also going to be shielding fellow business owners from potential personal creditors, nursing homes, divorce, death, disability. We have so many small businesses or family farms in the area. And if one partner or one family member who's part of that family farm goes into a nursing home, it could potentially jeopardize that whole farming operation, because any asset that partner is on is going to be an available resource for that individual's long-term care. So it's not just protecting couples, which is a lot of what I do, but it's also looking at business situations and how can we make sure that we're protecting business assets, including farms and the real estate associated with that farm. An asset protection plan also protects future beneficiaries from creditors. So we're going to talk about how this trust, we can set it up while a client, in this case, I'm going to use my parents. So let's just say they're my ideal client. I can set it up so I'm protecting them from their creditors, one of them being a nursing home, but also it can protect for the next generation. So when both my parents pass away and it is passing to me and my sisters, it can go to us in trust and there can be different rules that apply. And I'll give an example in the hypothetical using my parents at the end here, just so it kind of makes sense. And then an asset protection plan also is placing control in the hands of the client to shape the financial outcome of future generations. So, one of the things I've noticed since I've been trying to do these virtual seminars and connecting with financial advisors is a lot of times there's a misconception about these type of trusts and how much control you're able to have. And so what's important to know is that if you're going to look up irrevocable trust on the internet or Google that, you're going to find all kinds of things related to irrevocable trust that aren't necessarily true when it relates to the type of trust that I'm recommending that you use to protect assets. So I want to make sure that you know that if you're the client who's setting this up, that there's still a lot of control that you can have in this situation using these trusts. And again, I'll go into the specifics of it when we get to the hypothetical at the end. The two important points I wanted to make here. The first is that you're not hiding assets. So again, a lot of times when I meet with people, they seem uncomfortable or they feel like they're doing something that they're not supposed to be doing or that they're not permitted to do. So I always like to remind folks that this type of planning is allowed by law. That's why they do have the 5-year look back period. You do have to do it in enough time to make sure you're in compliance with the regulations that are out there. But it is something that the law does provide for you to be able to do. And the reason why they have done that is when I first started practicing law, it's been close to 12 years now. But when I first started practicing, right before I had started in this area, there was a lot more spousal protection that you could have. So if one spouse went into a nursing home, the nursing home typically wasn't able to attach to assets until the second spouse died. But that changed. And after, I think it was 2005 going forward, there is a lot more aggressive Medicaid recovery liens and going after certain assets. So again, this is an area of law that they allow for spouses to be able to protect assets for each other. So I wanted to make sure you know that you're not hiding assets. You are going to be disclosing these when you apply for nursing home care, if you would ever need that. It's just that you're permitted to do this type of planning by law. And the second thing is that an asset protection plan is a plan that uses the existing law to create barriers. And that's just protecting your personal assets from any creditors. And so creditors aren't allowed to attach to those personal assets. And so again, that's the benefit of the asset protection plan is you're not hiding them, you're just creating that barrier, and that barrier is a legal way to do planning. You are permitted to do this type of planning. So every person needs an asset protection plan. So I'm going to go through some things on here. And if you have one of these in your life, most likely you're going to want to do an asset protection plan. So if you have children, if you have a primary residence, if you have a vehicle, vacation rental, rental properties, in-laws, so if you have children who are married, for example, and any grandchildren, those are all reasons why you would need an asset protection plan. Another one that's not listed on here that I'll use in the example is just even having a spouse is a reason that you would want to do an asset protection plan, just so you can protect each other against the other spouse's care. So these are four reasons why you might need an asset protection plan or why every person would need one. The first is that so many people are underinsured, and I mean liability insurance, homeowners insurance, as well as long-term care insurance. So we're all walking around and most of us are underinsured. There are also a lot of exclusions from the policy. So when I meet with clients and they have a long-term care insurance product and I read through it, it's, disclosing all of the benefits. And then the next 10 pages are explaining when the benefits don't kick in or explaining why these benefits aren't actually going to apply in most situations. So when we're dealing with this, there are certain things that are going to be excluded from the policy. Another thing that's happening more and more is that insurance companies, especially in the long-term care industry, are going out of business just because of the cost as the baby movers have aged. So many people are needing long-term care that wasn't anticipated. And so a lot of companies are going out of business. And then the premiums increase. So again, like I said in my example of the 17% increase, that would be one situation. So you don't know year from year to year what the premium is going to do. So that would be another reason why you would want to do this type of plan. So what is the key to an asset protection plan? The first is that time is of the essence. So the goal here is that you're always comfortable with the type of planning that we're recommending. We want you to feel comfortable with it. And even if you don't understand all the specifics, just know that you are okay with what this plan is doing and it's reaching your goals. So we want everybody to have a comfort level with it. But that being said, the 5-year look back period doesn't start running until you set up the trust and actually transfer the asset into the trust. So if you're looking to get some sort of protection, time is of the essence, because the sooner you can start the look back period, the sooner you do get that protection. The cost. So one thing that you want to consider is the legal investment to do that. And then you also want to consider the attorney that you're engaging to do that. So I relate it to, and I've heard a lot of financial advisors relate it to, a doctor. So I have some electrolyte issues that I deal with personally. And so if I have a problem with my kidneys, I'm going to go to my nephrologist to handle that problem. I'm not going to my heart doctor. My heart doctor is good for cardiac concerns, but not necessarily for anything related to my kidneys. So you want to make sure you're engaging an attorney who actually does work in this area and is familiar with all the different rules for elder law. And that's the area of law that we call this. So that's not to say that we consider you an elder. It's just that this is the area of law that this type of planning falls under, and it's called elder law. And one way that you can check to see if you have an attorney who knows this type of stuff, I did a short video, it's about 10 minutes, and I did post it on our YouTube channel. So if you're a subscriber, or even if you're not, you can go to YouTube, and I go through a series of questions that you can ask your attorney to determine what their comfort level is with this type of planning. We also do have that posted on our Facebook page as well. So go check that out because it gives some pointers with that. The other thing is that you want to make sure you're doing an honest disclosure of assets to the legal professional. So I'm working with a financial advisor that I've had a longstanding relationship with. I really enjoy working with, and we have had the last couple of clients, we've had some issues because they didn't necessarily disclose all of the assets that they had at the time we were doing the planning. So now afterwards, we're kind of going through and figuring all of this out. It would have been helpful to have known that up front. Now, what we do with clients is we do give them an intake worksheet and ask them to fill that out. And again, you don't have to fill out everything, just whatever you're comfortable with, fill that out. But it is helpful for me as the attorney to be able to look at that and then make recommendations regarding what we should do with certain assets. The next key to a good asset protection plan is to have periodic checkups. So at our office, we recommend an annual review. We don't charge for that. We just want to go over everything, make sure you're comfortable. It's almost like a review appointment so that you can hear the same thing about your plan that we had put into place. It's just kind of review, but it kind of sticks in your head a little bit. You might think of additional questions. You might tell us of situations that have happened since I last met with you. And so that's all important as part of that checkup. You also want to consider alternative options. So again, people think of traditional long-term care insurance, and what we're talking about today is an alternative option. That's one of a couple of different ways that you can do it. And it doesn't matter what point of the planning you're in, whether you are husband and wife in your 50s and 60s and you're looking for planning and hoping to make it through the 5-year period, or if you're a child whose parent is looking at long-term care facilities, and you're either admitted or about to be admitted into a facility, there's always ways that we can help protect assets. So you always want to reach out to us or any legal professional to offer some insights about that. And then we always recommend that you include your family as much as you feel comfortable with it. And we're going to talk about why that's important, because your family members are going to help make this plan actually active and implement it. So we're going to talk about that. But to the extent that you feel comfortable, we are recommending that you include your family. So what are assets that you can protect? You can protect your home, you can protect rental real estate, you can protect non-rental real estate, so vacation homes, for example. You can protect IRAs, life insurance, bank accounts, business interests, collectibles, or future inheritance for that next generation. Okay, so this is how the trust becomes part of it. So when is the time to use an irrevocable trust? So my recommendation is you want to use it during life. So you're going to set it up now. So, and I'm going to use my parents as the example the whole way through this presentation. So if I were meeting with my mom and dad and I was recommending an asset protection plan, I'm going to recommend that it happen during their life, that they actually set up this irrevocable trust and fund it while they're living. And then what happens is additional assets can fund it upon death. There might be some beneficiary designations that we update to be the trust so that they take effect upon death. And then it does depend what assets we are protecting and who we want to protect it for. So again, the nice thing about these trusts is we can have a set of rules that apply while my parents are living. And then when they both pass away, a new set of rules can apply to my sisters and I. So the nice thing about a trust is you can have that flexibility. It does benefit you and your beneficiaries. So it's going to protect against divorce, debt, disability, and death. And these are the type of trusts. Now, I think that it's important for me to pause here because the title of this presentation is What's in Your Closet? And so the reason why I title it that is dealing with trust and the type of trust. Growing up, I had an aunt. It was my great aunt, my dad's aunt, who had this old farmhouse. And it was such a neat place as kids to kind of run around and explore. And when you would come up her stairs, it was like I said, it was an old farmhouse. I remember very vividly. She had this bright red carpet that covered all of the stairs. So you'd walk up these narrow stairs. When you get to the top of the staircase, there was the bathroom. And then right by the bathroom, there were these 3 steps that led to this door. And the door was bolted and locked. And I remember as kids, my sisters and I always thinking that there had to be something really, really important behind that door. I will admit there may have been a couple of times when we imagined the worst, like, is it like a dead body up there or is it a buried treasure? Like, what is it behind this door? And so we would spend hours just talking about what we thought it was going to be, how we could try to sneak up and see because it was bolted. So when I was thinking about how to explain trust, because I'm a very visual person, so how do you explain trust when trust can be very complicated? So I like to describe it as saying that a trust is just like a closet. So it turned out that when my sisters and I were brave enough to actually ask what was behind that door, my aunt said, well, it's a closet. And I remember thinking as a little kid, it's totally not a closet. She has something else behind that door. When she passed away, I was here at home over college break. It was during a summer. And my mom and I actually went to clean out my Aunt Catherine's house. And weirdly, I was most excited about opening up that locked door because I really wanted to see, was it a closet? Was there something in there? Well, it was a closet. And Aunt Catherine just had her Christmas decorations in there. So it was very anticlimactic and not exciting at all. But that imagery has stuck with me because I think of as I've grown up, when I bought my own house, when I moved back here, what was important. And anybody who knows me knows that my closet is very large. I have a lot of clothes and a lot of shoes. So to me, a closet has always represented a place that you put um, items. So like picture albums, for example. I know a lot of people have picture albums, their clothes, a lot of the things that are precious to them that they want to keep safe, they put in their closet. And so if we think of a trust as like a closet, you can create the closet just like in your house. You can design your closet however you want and you can put assets in that closet. And that's how I like to describe trust to my closet or my clients, is that a trust is like a closet. You can create it however you want. You can put whatever assets you want in there. And then depending on how you build the trust, how you build the closet, that's going to determine what rights you have, what access you have, and how much protection you get. Okay. So when we're thinking of these irrevocable trusts, It would be like you created a closet, you transferred assets into it, you shut the door and you locked it. Okay? That's what these irrevocable trusts, if you were to have an image, that's the type of image you would have. So we're talking about a testamentary trust. We're talking about a closet that is not created until you pass away. And at that point, that's when the trust is created, that's when the closet is created, and that's when the assets go into the closet or the trust. A revocable living trust is one where you create the closet, you put assets in it, you shut the door, but then you have the right to open the door and withdraw any asset that you want at any time. An irrevocable trust is one that you set up the closet, you build it, create the trust, you transfer assets into it, or you put assets into the closet, you shut the door and you lock it. That's an irrevocable trust. A special needs trust is one where you're going to set it up. It could be that while you're living, you have the ability to open the door, make some changes with the closet, but when you pass away, that closet is then going to someone else. It would be like saying if my Aunt Catherine had said, this closet now belongs to Sam, or anything in this closet belongs to Sam. That's really what a special needs trust is doing, and then it's describing when I'm allowed to open the closet door and pull assets out. Now, one thing I do want to make sure you know is even though these trusts that protect against long-term care are irrevocable, meaning you set up the closet, you shut the door, you lock it, doesn't mean you can't open that door. So all that it means is that you have given the key to someone that you trust. So in Pennsylvania, the rule is that if you set up an irrevocable trust and you transfer assets in it, if you yourself have the ability to withdraw the assets, then those assets are available for nursing home costs. However, if you set up the trust, transfer assets into it, and then allow someone else to make distributions out of the trust, then it is protected against nursing home costs. So in my example of my parents, again, I know my mom was on the phone, so I'm sure she'll appreciate this example, but let's just say her and my dad set up a trust. They put their house and assets they want to protect against long-term care into the trust. They shut the door and they lock it. Let's just say they give the key to me because I'm their favorite daughter. So they say, Sam, we're going to give you the key. All that means is that I have the ability to unlock the closet door and to pull assets out for my parents if they need it. The state of Pennsylvania says as long as it's not either of my parents and it's someone else, then those assets are protected against my parents' long-term care, both of their care. So if dad goes into a nursing home or if my mom goes into a nursing home, those assets are going to be protected. If my parents give me the keys and I won't open the closet door for them, let's say that, they put money in there and they decide they want to pull $10,000 out. Maybe they want to go on a really nice vacation. And I say, no, I'm not opening the door for that. I'm not using my keys to open the door. My parents actually have the ability under the trust to take the key back from me and to give it to someone else, as long as it's not either of them. So I have another sister, Jessie. So my parents could take the key from me and give it to my sister Jessie, and then she could open the closet door. They could also say, we're going to give keys to both Sam and Jessie, and then either one of us, or we could have one key, but it requires both of us to open it. So there's a lot of different ways you can do it. So even though mom and dad can't actually open the closet door and pull assets out, they can appoint somebody who can. And if that person will not, they can fire them and give the key to somebody else. So it is a very nice workable way that clients can put assets in trust and still know that they can get assets out if they would need to do that. The other important thing to know is that with this type of irrevocable trust, my parents could actually get rid of the closet completely. So they could say, we don't want this anymore, we're going to get rid of it. And if they did that, it would just require those key holders, my sister and I, to sign off on the termination, and all the assets could go back to my parents. Now, the reason they wouldn't want to do that is because those assets then are available for a nursing home or any other creditor that they have. But we can terminate it. So even though it's an irrevocable trust, this type of trust we can terminate. We can change who has the rights to pull assets out of it. We can change what assets go into it. We can change who ultimately receives that closet when mom and dad dies. The other thing is that if my parents set up this trust or set up this closet and put their house in there, for example, they're still going to be the trustee of this trust. So they can sell the house and invest the funds. They can sell the house and buy another piece of property. They're still in charge of it. So it's like they're inside the closet. They're allowed to rearrange it, take assets in and out, buy and sell assets out of the closet. They're allowed to do all of that. The only thing they're not allowed to do is reach in, take the key, open the closet door, reach in and pull out an asset. That's where whoever the key holder is can do that. But that's the only thing that my parents can't do. So again, even though it's an irrevocable trust, there's so much flexibility here for clients to be able to get assets that they want in the trust. Additionally, in this type of trust, we can separate the assets. So imagine you're in your closet, you have shoes on one side, clothes or jackets on the other side. And what I can do in this type of trust is I can say, okay, we're going to allow mom and dad, my parents' names are Denny and Denise. So we're going to allow Denny and Denise the ability to be able to pull out the shoes, okay, the shoes out of the closet. And what that means in the trust is that would mean the income. So if mom and dad put an investment account and it earns income, we can make it so that they can reach in and pull out only the income, but not the principal asset. So if they transfer $200 and it generates $2,000 worth of income, they can reach in and pull it out like they could the shoes in my example. They can reach in and pull out the $2,000, but they can't pull out the $200,000 without my sister and I, who are the key holders. So you can have access to certain assets, and it can be either income or it can be specific assets that you want. Okay, so if you had an investment account, you can say all the income on 100%, or you could even say I want access to 50% of the income. Whatever you would decide fits your needs, you can do that. And then you would be able to pull it out without those key holders. So again, it does allow you some flexibility as to what you can pull out. Now, anything that you have the ability to pull out of the trust or the closet, a nursing home or any other creditor can attach to that. So if Denny or Denise, my parents, if either one of them went into a nursing home and they had the ability to withdraw the shoes out of the closet or the income, then that income or the shoes would be available for my parents' long-term care. So that's just a general idea. And again, the reason I wanted to equate it to a closet is because I think it is easier to understand when you do that. So if you ever have questions about it, a lot of times I will refer to the closet and how that works. And here's a picture. So it's not an actual picture of my Aunt Catherine's locked door, but the one on the right is very similar to what it actually looks like. It just looked like there was something really important behind there. I mean, our Christmas decorations were nice. I don't want to, I mean, they were very, very nice, but it just wasn't what 12-year-old Sam thought was going to be behind there. So a revocable trust. So those of you on the call here, you guys might have a revocable trust. If you have a revocable trust, there is no asset protection in that trust. And the reason why is because you have the ability to open the closet door. If you have the ability to open the closet door, then it is available for your long-term care. Okay, so I just wanted to remember that. Now I do have someone that just joined, and I do think we need them to put it on mute. So let me see if I can do that here. It's my mom. I love you, Mom. I'm putting you back on mute. Okay. One of the questions I saw in the chat box that Tammy actually asked, and I'm very thankful she did, she was asking, can you protect IRA accounts too? So when we're talking in the example of the trust, we do not recommend transferring an IRA into the closet or into the trust. And the reason is because most people, it's a traditional IRA or a 401k, and you contributed to it and got a deduction, tax deduction, when you contributed. If you transfer that into the trust, it does trigger all of the deferred taxation when you do that. But the nice thing is that an IRA or retirement account is only available for your own care. So when I'm talking about my parents, Denny and Denise, for example, if my dad goes into a nursing home, my mom's IRA is not an available resource for my dad's care. So Pennsylvania does offer some protection against IRAs. If we have clients that have a lot in their IRAs, the other thing we do as part of the asset protection plan is we propose a drawdown plan, meaning over a period of years, we're going to draw down that retirement. Does mean we're going to pay tax on it, but then we can move it over into another investment vehicle that we can actually transfer into the trust. Okay, so thank you, Tammy. I'm glad that you brought that up. So irrevocable trust, I do have this slide here just to remind you that the irrevocable trusts do have to be created and funded prior to a claim. So this is dealing more with if somebody's suing you for property damages or you were in a car accident, the trusts have to have been set up and you have to have funded the trust in order for you to get protection against that claim. You can't know there's a claim out there and set up a trust and think you're going to get protection. So that's one thing I want to make sure people know. Now, I'm not done yet. I know how excited you guys are when you see our information at the end, thinking I'm done speaking. However, what I'm going to do is I'm going to give you a hypothetical. Okay, and then I'm going to slide over here and just bear with me. Okay, so this is a hypothetical I put together. It is based on my parents. So now, obviously, the asset values, and I just made this up. This is not specific to what they have, but I just thought of what I see most of the time when I'm meeting with clients. So I wanted to put together something and then use my parents just because familiar with their situation, it's easy to talk about. So my parents, Denny and Denise, both in their early 60s, and they've been married for 41 years. They have 4 daughters. So I am one of 4. I'm the third, actually. Three of the daughters, so all 3 of my sisters are married. They love 2 of their son-in-laws, but aren't fond of the one. So for our example, we're just going to say that there's one son-in-law that they don't like, and we're going to call him Darth Vader, just so that we can refer to him as something. They also have one granddaughter, Audrey, who has special needs. And then they have one daughter, that's me, who's not married. So just kind of planning for a spouse that you don't know. And then let's say I meet with my parents and they mention these concerns. So the unknown future spouse of the unmarried daughter. So can Sam pick a good husband? 2, the fact that one of their granddaughters, now they have 3 granddaughters. Audrey is their third, and she's the one who has special needs. And then they don't want Darth Vader or that son-in-law to receive any part of the estate if that daughter predeceases them or upon her death. They want to make sure that that actually goes on to the children. And then they want to provide long-term care protection as they age. So we want to make sure I wanted to list those concerns. These are common concerns that I see most clients have. So let's talk about their assets. So when I meet with them, they offer full disclosure. They fill out our nice intake sheet. We know that their primary residence is worth about $300,000. It is jointly owned, husband and wife. And that's how most spouses in the area, I think, have their deed, and it's just both of them on there. They have a bank account that has $15,000 in it that is husband and wife's name. They have an Edward Jones investment account that's jointly owned with $275,000 in it. They have an Edward Jones investment account that's just in Denise's name, just in my mom's name, $150,000. That's for her fun shopping adventures with me, of course. Edward Jones retirement, $200,000. That would be my dad's retirement, and then my mom's retirement is $100,000 at Edward Jones as well. My mom's is a little bit lower in this example because I wanted it to be a little bit realistic to real life. She was a stay-at-home mom, which is one of the hardest jobs ever. So she stayed home with us while we were in school and actually went back and got her education and certain things then. So she's now working full time. So I wanted to account for that in my example. So they have a little bit over $1 million here. And so what I want to make sure to talk about in this situation is, number one, it's a good thing they came to us in the early 60s because there is a 5-year look back period in Pennsylvania, and the look back period doesn't start until the trust has been set up and assets have been transferred to the trust. Okay. The second thing that we need everybody to know is in Pennsylvania, the average cost of care is $10,732 a month, which means that we'll pick on my dad, if my dad goes into care, receives long-term care, that's $128,784 a year that my mom is going to have to come up with in order to pay for care. So I think it's realistic to know what numbers you're looking at. So just knowing that it's $10,732 average in Pennsylvania a month. Now, again, there are some facilities in the area where we're dealing with the cost of care is actually $11,000 plus for care. And so again, that's just the average in Pennsylvania. So I wanted to make sure to tell you that. The other thing I wanted to talk about is which assets of these are exempt. So when you're looking down through these assets, there are a couple of things that we can say they're exempt. Now, the important thing to know about an exempt asset is it doesn't mean that it's never available for care. What it means is that while the individual is living, they meaning the nursing home, they cannot force the sale of the asset. Okay. So they can't force the sale, but if you do sell it, so when, for example, the primary residence is an exempt asset. If my dad is in a facility and my mom sells it while he's in a facility, even though it was exempt as a primary residence, as soon as my mom sells it, it becomes available. So if my dad is in a facility, that could be problematic. Okay. So even though the primary residence is exempt, I want to make sure people understand that it's only as exempt as long as it's the primary residence. Okay. The other thing is that if you are in a situation where you are looking in the future or you're right now applying for admittance into a nursing home, know that when you're going through and you're checking the box, there has to be an intent to return home to that primary residence in order for it to be exempt. So all that to say, there are certain things that are exempt, but only under certain circumstances. So the assets that are exempt is the primary residence, but only as long as it stays a primary residence. In this case, we're going to say my dad's in the nursing home, so my mom's retirement is exempt, meaning that my mom's $100,000 cannot be used to pay for my dad's care. And then right now, my parents have a vehicle each. My dad has a truck, and my mom has a like an SUV. So my mom would actually be allowed to keep the vehicle of highest value, whichever one that is. That's an exempt asset. Okay, so what we do when we're dealing with long-term care and figuring out what assets, primary residence exempt, retirement of the community spouse, the person who's not going to the facility is exempt, vehicle of highest value is exempt, and then Pennsylvania says the spouse that is not in the nursing home, the community spouse, is allowed to keep $128,000 roughly. Okay, that's about how much they're allowed to keep. So my mom would be allowed to keep that. So she'd be able to carve that out of their assets. Everything else is going to be available for my dad's care. So his retirement's available, their joint investment account is available, their joint bank account is available. Interestingly, so is my mom's investment account. The $150,000 that's just in her name, even though my dad's name is not on it, that is also an available resource. Okay, so it doesn't matter how it's titled, it's still going to be available. So I wanted to make sure everybody knew about that. The other thing is that even if an asset is exempt, like the primary residence, it is still subject to a Medicaid recovery lien, which means that if my dad dies while he's in the facility, and let's say my mom had predeceased, the nursing home can put a Medicaid recovery lien on it, which just means that even though they couldn't force the sale while it was the primary residence, when my parents pass away, at that point is when they'll force the sale and they'll recover what they paid for care. So these trusts that I'm talking about in my example, they do protect the asset as long as it's been owned for 5 years, and they do prevent the Medicaid recovery lien, because the Medicaid recovery lien is only for assets that are passing through will. Okay, so anything with a beneficiary designation, anything that's owned in a trust, that's not going to be subject to a Medicaid recovery lien. So I think it's also worth pointing out that we want to make sure that there are always designated beneficiaries on every account that we possibly can. We do not want the designated beneficiary to be the estate of. So in my dad's case, we don't want it to say primary beneficiary is the estate of Dennis Wolfe, because if that's the designated beneficiary, then a Medicaid recovery lien can happen and come back on anything that's paying into the estate. The other thing is that if there's a designated beneficiary, we're able to avoid probate. And so you don't want to make something that is not normally subject to subject to the probate process. Okay. So I wanted to make sure I talked about that Medicaid recovery lien there. And then I talked about what assets are available. So when we're going through this, the bank account, the joint Edward Jones account, my mom's Edward Jones account, and then my dad's retirement would be available if my dad is the one who's going into care. Okay, so I think we're clear on assets. So now what I want to do is I want to explain what our office would recommend if my parents were to walk in the door and we had them if they, these clients had assets like my parents, what would we recommend? And I'm going to show you what that looks like. Okay. So I'm going to stop sharing this screen. Just bear with me. I am going to now go to a visual. Like I said, I'm a very visual person. So this is an example. I'm going to slide down so you can see the whole example. This is an example of a visual that we would do for somebody who was doing an asset protection plan. In addition, we also put into writing what we're doing and why we're doing it. And then we send it to the financial advisor to kind of get their blessing on it, make sure they're okay with everything, get them on board with a plan, and make sure that it's coordinated as well with the accountant, okay? So when we're talking about my parents, now I know that I can only share one screen at a time. So just so we know, there's a primary residence, there's a bank account, there's an investment account, there is an investment account in my mom's name, and then there's both of them have retirement, okay? So first thing we need to make sure to do is that we are always still going to recommend that my parents have a will for non-trust assets, okay? So for example, I'm not going to recommend that my parents transfer their bank account that they write checks out of every day into the trust. Okay, so we want them to still be able to pay bills, do whatever they want, not jeopardize their standard of living. So the joint bank account is going to stay outside of their trust in their joint names. Okay, so, but that being said, we want to make sure that they have a will, because when the second of them dies, that bank account is distributed to the beneficiary through the will. So we still want to recommend that they have a will for their non-trust assets. Sometimes they get that question, is do we still have to have a will? Second thing is that if my parents had any underage children, they could name a guardian in the will, as well as anybody here who's on the call who has grandchildren. You can't name a guardian, but you can name a custodian. A custodian is someone who's in charge of those funds until that individual reaches a certain age. So for example, if you would just be doing basic estate planning and not the trust, which we're looking at in this picture, you would want to name a custodian for those underage kids. And you can do that in Pennsylvania up to age 25. The third recommendation that we would make, without even getting into the trust, the third thing we're going to recommend is that you're going to add husband's names to any of wife's accounts or husband's accounts, except for retirement, but any individually owned asset that's non-retirement, we want that to be in joint names if it's not being transferred into the trust. And the reason is because if the investment account that's just in my mom's name, if she doesn't transfer that into the trust, then that means when she dies, that account is subject to probate, meaning that we have to go to the courthouse and go through the probate process in order to transfer that where it needs to go. And a lot of times husband and wives don't realize that. So we would recommend that even if my mom doesn't transfer it to a trust, that she add my dad's name to the account, okay? So that way, if she dies first, my dad doesn't have to probate. Probate wouldn't have to occur until the second spouse dies then. So we want to make sure that. Again, we want to make sure that everybody knows the individual assets is still available for the long-term care of the spouse. Retirement is exempt, but if you name the spouse as the beneficiary, then it does subject to nursing home costs. So if my dad says, I'm going to name Denise as my beneficiary, and my mom says, I'm going to name Dennis, and my dad's in a nursing home and my mom dies, remember, my mom's retirement was not available to her. But when she dies, if my dad is listed as the beneficiary, it then does become available for him. So if we name one of these trusts as the beneficiaries, what it does is it pays into the trust first, okay? Or it has the option to pay into the trust first, so that we can protect the retirement for the beneficiary, the spouse who's the beneficiary. We name the spouse as the contingent so that if when my mom dies, for example, if my dad's not in a nursing home, we're going to name my dad as an individual as the contingent beneficiary, and my dad is the trustee of the trust. Remember, he can move the closet or the assets in the closet around. So he's still the trustee, and as the trustee, he can disclaim, which means that he can say he doesn't want the retirement to pay into the trust. And if he's listed as the contingent beneficiary, then he can receive it outright. So we can do it that way to make sure that we can offer the protection. And if we don't need it, that's fine. We can disclaim and it goes to the spouse. But we can't do it the other way. We can't have it pay to the spouse as the primary and then try to disclaim, because the nursing home won't allow that. So even though retirement is exempt for the community spouse, that it's important to know that if they're the beneficiary, or if the spouse is in the nursing home as a beneficiary, it then becomes available when that spouse dies. Other thing to know is that in these trusts, you can include transfer restrictions. So I'm working with a client right now who the primary residence, they want to allow a child the right to purchase it. And so the trust can allow those provisions in there. And then you can also designate the trust as a retirement beneficiary, because that prevents lump sum distributions, meaning that if my parents designated a trust as the beneficiary for the retirement, I can't pull it out all at one time and be subject to all of the income tax. So that's beneficial as well. That being said, that's kind of all the preliminaries of it. This is an example of what we would recommend. So let's start with this trust over here. So we titled it the Wolfe Primary Residence Protector Trust. The trustee of the trust, that's the person who's in charge of it day to day, can make investment decisions, can make buy, sell decisions. That's the grantors. That's my parents, because the grantors are the person who set up the trust. So my parents can still be the trustee of the trust that's going to own their primary residence, which means they can decide if they'd ever sell it. They can decide to invest those funds. They can do anything related to the assets inside the trust, okay, but for withdrawing them, all right? Anything else that you can do now as an individual, you can do as the trustee of the trust. We're going to name a successor trustee. So in this case, I have myself listed there. And that's just, because I'm the favorite. So we put me there as the successor trustee. The trust protectors can be all of my sisters and I, meaning that all of us have a key to open the closet door. Okay. Remember that the trustee is just the buy seller in charge of investing the assets. And so my parents can set it up so that I can make those decisions. But as far as withdrawing assets, all of my sisters and I have the ability to do that. And they might say that we have to work together, so that way that everybody's involved. In this case, the income beneficiary during life is going to be my sisters and I, and the principal beneficiary is going to be my sisters and I. So what that means is if my parents sell their house, let's say we said the primary residence was worth $300,000, they sell it, they want to downsize. So they buy a house for $150,000. That means they have, and they can do this as the trustee, they can sell it. The sale proceeds are payable into the trust, which just means they open up a bank account or investment account titled the Wolfe Primary Residence Protector Trust. They deposit that check in there. They can then purchase a house. Let's just say they downsize 50%. So they buy a house for $150,000. They take that additional $150,000 and they invest it. They didn't need my sisters and I to be involved in that decision at all, because everything stayed within the trust. That's just like if you were selling shoes or clothes out of your closet, you can do that, because as long as the value of the closet remains the same, you're fine. Okay, so they would still be allowed to do that. It would only be if they needed us to pull out those funds for some reason, vacation, a car, something like that, okay, that they would be able to do that. Then upon death, so upon the second spouse's death, then the trust gets divided, the closet gets divided 4 ways. Sorry, there are 4 of us. So each of us, that's what each of this block down here is for. We each get our own trust. So what that means is that I, as the trustee, can sell the primary residence if my parents haven't already done so, and then just divide the sale proceeds equally among my sisters and I. The benefit of it going in trust is that it protects my sister that is married to Darth Vader. So if my sister dies either before or after she receives the money, because she receives it in trust, it is protected against that spouse. And if the children are underage, it sets up the parameters for when they get distributions. Okay, so that's one thing that these trusts do. The other thing that it does is it is going to protect against any creditors. So if Darth Vader divorces my sister, or my sister divorces Darth Vader, he's not entitled to the assets inside the trust. Okay. So that's why my parents decided to put it in trust for us. And that's not to mention that I'm not married. So they don't know if I'm going to pick a good spouse. So whether I marry somebody good or bad, it doesn't matter, because my assets are being held in trust when they pass away. And if you'll notice, we can all serve as our own trustee. Okay. So that's because if I never owned the individual assets myself and it was owned in trust for me, then I do get the protection because I never owned it as an individual and I could still be the trustee. The HEMS here, that stands for health, education, maintenance, and support. So I can distribute for whatever I would need. I can buy a house in here. I can go on vacation in here, um, taking the money out of the trust. The other thing here is upon Krista's death, Audrey's share can be held in a special needs trust for her. So you'll see here the beneficiary is Krista per stirpes. That means if something happens to Krista, her 2 kids receive her 1/4 share. Audrey's share can be held in a special needs trust, which if Audrey is qualified for any government benefits, she'd still maintain those benefits and still get the inheritance. So that's important. And then Krista's other child could receive it in trust as well. It's just that it doesn't have the special needs language in there, but it still offers protection against spouses, car accidents, that kind of thing. And then here, because I don't have any kids right now, if I ever would have kids in the future, if something would happen to me, my share would go on to my kids because it says per stirpes. That means any children I might have at the time of my death. If I pass away and I don't have kids, the trust is going to say that my 1/4 goes back to my other sisters because that's what mom and dad have decided they wanted. Okay, so again, you're setting up the rules in the closet to be whatever you want it to be. We can make it go wherever. We can make these rules different for each of my sisters and I about when we can receive distributions. So you can make it as flexible or as restrictive as you want for the beneficiaries. But the important part to remember is it protects mom and dad's primary residence, which means that if dad goes into a nursing home, the house is in this trust and mom sells it, the sale proceeds are protected. They're not available for my dad's care. And it also protects against a Medicaid recovery lien. So if mom and dad both pass away, we know the value of the house is going to go on to the future generations. Okay. So that's why we use this trust a lot for the primary residence, is because it's protecting the spouse that's not in the nursing home. Because if dad goes into a nursing home and mom decides she wants to go into assisted living or into a smaller apartment, she's going to need the funds inside this trust to pay for that. Well, if my dad's in a nursing home, all that money goes to the nursing home. So what this trust allows the flexibility is, even though your primary residence is exempt, it allows you to then be able to sell it or allocate the funds as you would need. Okay. So that's why we would recommend a primary residence trust. This trust over here, the Wolfe Income Only Protector Trust, we're going to recommend 2 things. First of all, we're going to recommend that both of my parents update their retirement, their IRAs, so that this trust is the primary beneficiary and then their spouse is the contingent. So that if my dad goes into a nursing home, it's this trust and then my mom's going to name this trust and then my dad. Because if my mom is not in the nursing home and she dies and my dad's listed as the beneficiary and he's in a nursing home, all of that money goes to the nursing home. Or more importantly, if my dad's qualified for Medicaid, it kicks him off Medicaid, but then my sisters and I are going to have to apply again once that money is used or spent down. So this way it would allow it to pay into trust and be protected. Again, if a spouse is not in the nursing home, remember, the spouse can disclaim and it can pay outright, and then we don't have to worry about it. The other thing we're going to transfer into this trust, my recommendation would be, if my parents are not touching or using the investment account, we would transfer it into this income only trust. And what that would allow my parents to do is take the interest and dividends every year off that investment account, but it would protect that $200,000. They had it was 150. They had 150,000 that was in my mom's name. If we put that in here, they can live off the interest and dividends and withdraw that without my sisters and I being involved. If they need additional funds out of that, they just need to come to my sister and I. We have the key, we can open it. And remember, if we say no, they can take the key and give it to somebody else. Okay. So we've used this as a beneficiary for retirement as well as to transfer the investment account. This trust over here, the Wolfe Protector Trust, this one is a little bit different because we're not putting real estate in it. So the primary residence trust, it's different from the income trust because remember, my parents could take the interest and dividends off of it. This trust would be used that if my parents said, well, we don't need the interest and dividends off that investment account, then we would put it into here. Because remember, if they have access to the interest and dividends, then so does the nursing home or any other creditor. So if they don't think they want access and they're just going to come to my sisters and I anytime they want to receive anything out of the trust, we can put the whole account into this trust, and then the income is not available for long-term care. Remember, mom, dad can fire us at any time and appoint somebody else. They can change who the beneficiary is. So there's so much that they can do with these trusts. And then you'll see the little star down here at the bottom of each of these trusts. And what it says is upon the second spouse's death, anything that's in here is going to pay over into this trust and then get divided into equal 1/4 and go to my sisters and I in trust. Okay. So in this case, we'd recommend primary residence into this trust, the Wolfe Primary Residence Trust. We'd recommend my mom's investment account either into the Wolfe Income Only if they want income off of it, or into the Wolfe Protector Trust if they want to protect the whole $150,000. And then this trust we're going to recommend as the beneficiary for their retirement. And by doing that, we're able to protect quite a bit of money, at least $450,000 for my mom. So what that means is that if my dad goes into care, it's not that she's just keeping 128,000, she's keeping 128,000 plus the 450,000 that we've transferred into the trust. She can use those funds to help pay for my dad's care if she wants to, but she can also use that because depending on how old my parents are when this happens, my mom could live another 20 years and the cost of living only goes up. So what it does is it gives the flexibility for the spouse to be able to say, I'm going to use certain assets and not others. The other nice thing is that you can then say that when the second spouse dies, if you want these funds to go to pay the nursing home at that point, you can do that as well. Okay, so just because you put them in trust doesn't mean that that you can't use the funds to either pay for a nursing home or when both of you have passed away to make a gift to the nursing home. Okay, so I know that I went through a lot of information here. Just as a reminder, I always post the virtual seminar after. So usually we post it in the month after we actually tape it. So I'm taping it now. We'll post it in October. We post that on our YouTube channel as well as on Facebook. So if you haven't subscribed to our YouTube channel already, we recommend that you do that, or to follow us on Facebook so that you can get updates about when we post it, because you can always go back and listen. The other thing that I've done is that I have taped some short questions and answers, and I posted that on our YouTube channel as well as on Facebook. So I encourage you guys to go check those out as well. I don't see any other questions. I will remind you that we're going to send out an email link where you can log on and take a survey. I always appreciate hearing what you liked, what you didn't like, asking further questions. You're always welcome to do that. And it just gives an idea of what topics you would want in the future. So please know that we're going to do that. I do see that Tammy says, what about a joint account that has a child as the joint owner, and perhaps a joint account is actually the child's money and not the parents? Oh, Tammy, thank you so much. I didn't even prompt Tammy to ask these questions, so I really appreciate her questions. So first thing is, if you have a child as a joint owner, what you have to know is that it is an available resource for long-term care, okay? So if, let's say, my mom adds my name to the joint investment account, it is still an available resource, okay? So if my mom goes into a nursing home, they are, whether it's my money or my mom's money, they're actually going to take that. And the assumption is that it is all my mom's money, unless I can prove that I contributed money. Okay, so the whole thing would be available for my mom's care. All right, so and the other question is, sometimes people say, well, can I add my children on as joint owners, and will that protect the asset? And the answer to that is, it makes that asset then subject to your child's creditors. So if I would ever get divorced or have any creditors, it makes that my mom's asset that I was added as a joint owner then subject to all of my creditors. So it's not good for my mom because it makes it subject to my creditors. And it's not good if it's my money because it's still available for my mom's care, even if it is my money. There is that presumption that it's going to be an available resource. Okay, so thank you, Tammy. Yes.
Yeah, Samantha, Bob Finch here. You enumerated a number of reasons why someone might use a irrevocable trust to protect assets, etc. Under what circumstances would you ever use a revocable trust,
Yes.
a living revocable trust?
Yes. So we see this often in two situations. So the first is when someone is trying to avoid probate. So maybe your kids don't live locally, and so you don't want them to have to go to the courthouse and be sworn in and have to go through the probate process. So if you set up a revocable trust and transfer your assets while you're living into that trust, then you avoid probate when you pass away. So that would be one reason we see people do it. The second reason is that you may say, like in my parents' situation, that when we die and it goes to the kids, we want it to go in trust because we want to protect it against our kids' creditors. So any in-laws, or so to make sure that it goes to the grandkids if something would happen to your child. So a revocable trust kind of creates the structure that allows you to then have trust for each child. So a revocable trust avoids probate while you're living, and then it can create asset protection for the next generation. It will not provide asset protection while you are living, though. Does that answer your question, Bob?
Yeah, I think so. We worked with you before on some of this stuff. I think I don't remember now
Yes.
how long ago it was, but within the last 2.5 years since we moved to
Yes.
Pennsylvania. So I think it may be time we set up an appointment and kind of review some of these things. And
Absolutely.
yeah,
Absolutely. Yeah. And we don't
and your
charge for the
your
review
your
appointment. So,
location, your office now it's still in the same building where you were. It's just on what
on
the
the first floor.
on
Yes.
the
So we're
first.
still
Okay,
in
that's right.
Blandis complex. We're
Yeah.
just now in
Uh,
suite 206, which is on the first floor.
Yeah, I remember now that the building had a strange floor numbering system.
You're right. Absolutely. So now when you walk in, you're going to pass the receptionist for DL George and turn left when you get to the elevator and walk down that hallway. And we're down
Okay.
there.
Yeah,
Okay.
we'll be in touch with you probably today. We need to set up an appointment to sign off on the renewal on the mental health power of attorney that we have with you. So
Perfect.
we'll
Perfect.
be
Bob, you're always
we'll
on
be
top of things, and I appreciate that.
okay. Well, thank you very much for doing this. We look forward to more in the future.
Yes. Well, hopefully I'll see you next month. We'll get to talk about all the fun tax rules. So it'll be a good time.
Right. Okay. Thanks again. Bye bye.
Yes. Take care. Hi, Louise. Okay. Does anybody else have any other questions? Okay, I'm not seeing any on the chat box. Like Bob did, you can always unmute yourself as well. So thank you guys so much for being on the call. Like I said, we will post it on our YouTube channel, and go check out our YouTube channel and our Facebook page. We will be announcing when our website is up, and all of this information will also be on there. So, and to the extent that you're willing to do it, we appreciate you filling out the survey and letting us know what you liked, what you didn't, and any recommendations about future topics. Okay?
One last question,
Yeah.
Samantha. How do we get into your YouTube page? Just put in Samantha Wolfe, attorney at law,
Yeah.
or something like that.
If you just type in the law offices of Samantha K. Wolfe, all our channel will come up. And Bob, you can
Okay.
actually then subscribe to it, and then you'll get a notification anytime that we post a new video. Okay.
Okay. Good. All right.
And you're
Thanks very
welcome
much.
to put comments too, Bob. So any questions after you've watched a video, type a comment and I will respond or do a follow-up video explaining that. Okay.
Right. Okay. Thanks again.
All right. Yes, absolutely. Everybody take care, and thanks for spending your lunch hour with me. All right. Bye-bye.